Hi, Ayush.
Hi, Amit.
In 1 minute, we'll start, Neeluji.
Yeah.
Please do.
Yeah.
Good evening, everyone, and welcome. It is a pleasure to have you all here today to discuss a topic that is of critical importance for businesses involved in the US-India trade. Today's webinar on tackling tariffs, how the US government plans to prosecute tariff evasion, and what Indian companies can do to protect themselves, is hosted by the Indo-American Chamber of Commerce, North India Council, in association with our esteemed partners, Khaitan and Company, a leading law firm in India, and Quinn, Emanuel, Urquhart and Sullivan, LLP, a leading law firm in the United States. United States has imposed steep tariffs on Indian goods, with the overall tariff burden rising to as much as 50%. Key affected sectors are textiles, gems and jewelry, leather, machinery, furniture, footwear, sports equipment, chemicals, and marine products. However, some sectors such as steel, aluminium, copper, passenger vehicles, pharmaceuticals, electronics, humanitarian donation, and informational materials are exempt. The shipments in August from India to US plunged to USD 6.7 billion, down 16.3% from July. The global trade has become even more complex as continuous change in tariff policies continue to fuel uncertainty across international markets and may disrupt supply chains. The US government is significantly escalating its efforts to prosecute tariff evasion in addition to rigorous customs control. On July 10, 2025, officials from the US Department of Justice announced a significant shift in its strategy for fraud enforcement, consolidating resources from the Criminal Division and the Civil Division to create a new market, government, and consumer fraud unit within the Criminal Division's fraud section. The consolidated unit will focus on investigation and prosecution of trade fraud and tariff evasion, in addition to its historic focus on market manipulation and government procurement fraud. This effort is expected to target companies and individuals engaged in customs fraud schemes such as purposeful misclassification, undervaluation of goods, falsifying country of origin declarations, and intentionally relabeling and rerouting shipping of goods through low tariff countries. In September, the DOJ formed a new trade fraud task force in partnership with the Department of Homeland Security, which signals a shift from traditional civil penalties to a more aggressive criminal prosecution. The DOJ is also increasingly using the False Claims Act to pursue tariff evasion. It is also offering cash rewards to whistleblowers who report trade violations, creating strong incentives for employees and competitors to report suspicious practices. Companies now face scrutiny across all sectors, with authorities demanding complete accuracy in documentation and transparency in operations. Indian exporters are required to accurately report three key data points: tariff classification, country of origin, and product valuation. With rapid change in tariff rules, staying compliant has become imperative and increasingly challenging. This will certainly increase higher compliance costs in addition to the increased tariffs. We have with us today a stellar panel of thought leaders and practitioners to give their insight on navigating possible tariff prosecution in the United States, how exempt sectors can prepare for possible tariff imposition in the future, and advise on what precautions Indian companies can take to remain compliant in these uncertain times. Let me take a moment to introduce our panel. Our first panelist is Daniel Koffmann, partner Quinn Emanuel. Daniel Koffmann represents companies and senior executives in sensitive matters involving government investigations, corporate crisis, internal investigations, criminal indictments, and other significant business, legal, and reputational challenges. He advises clients on a broad range of litigation and compliance issues, including alleged corruption, securities fraud and insider trading, sanctions and export control violations, tax evasion, accounting fraud, the False Claims Act, money laundering, and civil and criminal forfeiture proceedings. He also brings affirmative claims against government regulators and agencies when statutes, regulations, and other government actions infringe on clients' rights. Dan's practice is global, and the majority of his matters involve defending foreign individuals and organizations facing scrutiny from US prosecutors and regulators. Dan is an accomplished trial and appellate advocate. He has tried numerous federal criminal cases to verdict and has briefed and argued appeals in several federal courts of appeals in New York's First Department. Most of Dan's work, however, is out of the public eye, assisting clients in avoiding indictment or other media scrutiny altogether. He regularly persuades prosecutors, regulators, and other adversaries to decline prosecution or enter into negotiated resolutions on favorable terms. In recognition of his achievements, legal periodicals including Law 360, Legal 500, and others have identified Dan as a rising star of the white-collar bar. And the second panelist is Robert Zink, partner Quinn Emanuel. Robert Zink is a former head of the U.S. Justice Department's Criminal Division Fraud Section. He's a trial lawyer and member of the firm's investigations, government enforcement, and white-collar criminal defense group. His practice focuses on trying high-stakes matters, defending corporate entities and individuals under investigation by federal and state law enforcement authorities and regulators across the United States, and providing advice and counsel to corporate entities in connection with the design, testing, and implementation of corporate compliance programs. Prior to joining the firm, he served in various capacities at the U.S. Department of Justice, most recently as Acting Deputy Assistant Attorney General in the department's Criminal Division, and before that, Chief of the Criminal Division's Fraud Section. In these positions, he oversaw more than 150 federal prosecutors nationwide and supervised federal criminal investigations and prosecutions involving securities fraud, commodities fraud, healthcare fraud, government procurement fraud, etc. Mr. Zink speaks regularly on white-collar matters at conferences and symposiums around the globe and has served as a guest lecturer at several law schools, including Harvard Law School, Georgetown University Law Center, and the George Washington University Law School. Our third panelist, Amit Kaurishankar Pandey, is the Executive Vice President and General Counsel, GlaxoSmithKline Pharmaceuticals Limited. Amit is a commerce graduate with a postgraduate degree in international law, where he proudly clinched the gold medal. He is also a distinguished fellow member of Institute of Company Secretaries of India, New Delhi, and his journey in the realm of corporate legal advisory spans over more than 2 decades. His expertise lies in navigating the intricate landscapes of litigations, management, cross-border merger and acquisition, and the astute administration and management of legal functions. With a rich tapestry of experience across diverse sectors, including steel, industrial engineering, medical devices, and pharma, he has honed his skills working with esteemed Indian and global MNCs such as Ferroalloys Corporation, General Electric, Honeywell, GSK. Currently, he is providing his services as Executive Vice President in GSK. In this role, he's entrusted with responsibilities to advise Board of Directors of a listed entity and assist senior management in achieving organizational commercial objectives, mitigating legal risks. He thrives on challenges, and his passion lies in crafting legal strategies that not only protect business but also propel them towards unprecedented success. Our final and fourth panelist, Ayush Mehrotra, he's a partner in indirect taxes, customs, international trade, and regulatory affairs at the firm's New Delhi NCR office. With over 16 years of experience, he specializes in international trade and customs matters, including advising on tariff implications of US and global trade policies, compliance with dual-use export controls, BIS quality regulations, and navigating international sanctions regime. Ayush has extensive experience supporting multinational and Indian companies on cross-border restructuring, tariff optimization, supply chain risk assessment, and trade dispute resolution. He regularly appears before customs and regulatory authorities, appellate bodies, and higher judiciary in cases involving complex customs and trade issues. Known for his strategic insights, Ayush frequently publishes on topics concerning international tariffs, customs, policy developments, and trade facilitation. He has been awarded and recognized as one of the top 100 lawyer, more than 10 years, legal power list, Forbes India 2023, recommended and key lawyer, legal 500, Asia Pacific rankings 2025. With that, I request Daniel and Robert to commence the presentation. Thank you.
Okay. Thank you. So thank you, Vanita. That was a very kind introduction. And with that overview, I don't know how much there is left for Rob and I to say. That was a very thorough and very excellent introduction. So what Rob and I wanted to talk about today is sort of the legal underpinnings of how the US government will go about investigating and prosecuting tariff evasion, as well as on a practical level, how the government, the US government, will investigate and ultimately attempt to prosecute those cases. So, as I'm sure you all know, US tariffs are a bit of a moving target. There was an executive order that the president issued in July, initially imposing a 25% tariff on India, as well as a number of other levies on other countries. That has had exceptions. It has gone up, it has gone down. As I'm sure you've seen in the news, what the tariff is on any given country is I haven't checked the news in the last 10 minutes, so it could be different since the webinar began. But that was clearly the intention of the US government has been to impose tariffs on Indian goods and to increase pressure on the Indian economy. As stated in White House publications, it was retaliation for Indian companies' purchases of Russian oil. There's been news as recently as yesterday about that. So I think, notwithstanding the uncertainty about how much and how long and what exactly these tariffs will cover, I think the prudent course is to assume that there will be tariffs. They may be substantial, and that it behooves Indian companies to have an understanding of how the US government may intend to prosecute companies who do not abide by these tariffs. So with that, I'll turn it over to Rob to talk about some of the legal background.
So, as Dan explained, the tariffs are now a reality, at least for Indian imports. And so the question then becomes, well, what are the consequences for not complying with U.S. tariffs as they relate to India? And generally speaking, there are two sets of consequences. The first set of consequences, which I'll talk about in a second, are criminal consequences, which carry with them jail time and significant criminal penalties. The second set of consequences are civil consequences, which carry with them basically the threat and the reality of monetary penalties. So with that in mind, we'll just orient you to this slide, which there's a lot here, but I'll kind of decode it quickly for you. The first three statutes listed on this slide, that's 18 U.S.C. 541, 542, and 545, are export/tariff statutes specifically. And the first two statutes, 541 and 542, in substance, criminalize making false statements to get a product into the United States. So again, we'll walk through the most common false statements that are charged by the U.S. Department of Justice. But the idea is that a company or an individual is lying on some kind of form to not pay a tariff to get their product into the United States. Those are the first two statutes. The third one is something that, hopefully is not of terrible relevance to folks on this call, which is just the straight up smuggling of goods in the United States. So this is putting stuff on a boat under cover of darkness. It goes into San Francisco harbor and it's unloaded onto a dock. That's just smuggling stuff that's subject to a tariff without any paperwork whatsoever. And then the rest of the statutes are just general anti-fraud statutes, which also run kind of coextensive with the first two statutes. You can't lie in government documents or government forms, and you can't lie to get money, which is just simply wire fraud. And then the last statute I'll highlight for you before we move on is 50 U.S.C. 1705. It's the second from the bottom. It's we call it the IEPA statute, which is named after the act which passed the statute. And what it does is it simply criminalizes willful violations of these executive orders that President Trump has issued. So President Trump has issued an executive order. He says you've got to pay X percentage tariffs on Indian imports. And if you don't do it, and you don't do it willfully, it's a separate violation of law. So those are criminal consequences. The bottom line for listeners are, if you lie in forms, you're in big trouble. And the consequences could be severe. We're talking jail time for individuals, corporate charges against companies, and significant monetary penalties. That's criminal stuff. And now we'll turn to civil stuff. There are principally two statutes that apply to tariff fraud as it relates to kind of this civil universe. The first is the False Claims Act, which I'll talk about in a second. And the second is this individualized statute specific to tariffs, 19 U.S.C. 1592. So let me start with the bottom one. This is the civil analog to the criminal statutes. You can't lie in government forms. But here's where this one is a little bit different. There are no criminal consequences, but you can violate this statute by simply acting negligently. So even if you didn't intend to lie, or you weren't reckless in stating something on a form, if you were just negligent, you can get charged with this civil violation under 1592. And there are significant monetary penalties associated with that violation as well. Okay. And now turning finally to the False Claims Act, just in 30 seconds, the False Claims Act kind of prohibits two general types of conduct. The first is lying to get money from the U.S. government, which would not be the case here. The second is lying to avoid paying money to the U.S. government. That's a so-called reverse false claim. And so the idea here is that from a civil perspective, folks are lying on government forms to avoid the payment of taxes. And so there are monies due and owing to the United States, and therefore it's a false claim. The false claim being the false statement on the form. The rub with the False Claims Act is the penalties are significant. You can get up to treble damages. That's 3 times the amount of damages that you ordinarily could. So the monetary penalties associated with the False Claims Act are significant. And of course, under 1592, simple negligence can trigger a violation of law. So long way of saying there are a number of tools in the Department of Justice toolkit to combat tariff fraud, both criminally and civilly, and they're significant.
Yeah, and just one point to add there is that both of these civil statutes are enforced by the Department of Justice. there's a civil division within the Department of Justice that would be responsible for prosecuting those claims. So I said before that there was uncertainty about the amount of tariffs, what they apply to. There's actually even more uncertainty that you may have heard about, which is that there was a decision a few weeks ago, about a month ago now, from the Federal Circuit, the Court of Appeals for the Federal Circuit, which is one of 13 federal courts that sits right below the Supreme Court. And in that decision, the court said that IEEPA, which you heard Rob mention a minute ago, is not a basis for the president to issue tariffs. So what that means is not only are the potential penalties that Rob talked about up to 20 years in prison for violating IEEPA, not only means that those potential penalties are off the table at the moment, potentially, and I'll come back to that, it even calls into question the very enforceability or legal underpinnings of all of these tariffs against India as well as other countries, because in issuing these tariffs via executive orders, the president invoked IEEPA as the basis for imposing those tariffs. And now there is a federal court of appeals saying that IEEPA does not authorize the president to issue these tariffs. So there is even more uncertainty at the moment about what the impact of all of these tariffs really is. That said, the Supreme Court has agreed to hear the government's appeal of this decision. That will occur later this year. The U.S. Supreme Court term begins in October and runs effectively through June. So I don't believe that there's an argument date for that yet, but as I'm sure many of you know, the highest profile, the most controversial Supreme Court decisions are usually issued towards the end of the term in late June. So I think we may be on pins and needles for several months until we have clarity about exactly what these, whether these tariffs are enforceable, and if so, how.
And Dan, just to say one thing on this, which is even though the executive orders themselves might be legally invalid, that does not mean you can still lie on government forms. So even if you make a false statement, even if the EO is not enforceable, if you lie about the country of origin, what the value of the products are, it's still an independent, separate federal crime, irrespective of what the Court of Federal Claims has done, or the Federal Circuit has done, or the Supreme Court.
Rod, do you want to talk about the DOJ?
So as Vanita kind of highlighted early in the introduction, there's breaking news to the Department of Justice, and that is the creation of the DOJ Trade Fraud Task Force. So when I used to work there, I worked in a place called the Criminal Division's Fraud Section, which has principal authority over white-collar offenses throughout the United States. The reason that's relevant to this discussion is that's where the Trade Fraud Task Force is housed. It's parked in a specialized white-collar unit, and the idea is that there will be a specialized set of prosecutors and federal agents dedicated to investigating and prosecuting criminally, that's the key here, criminally violations of the tariff laws and export control laws. So it remains to be seen how many prosecutors and agents will be dedicated to this task force. But DOJ has very, very publicly said this is one of their top 2 priorities, along with healthcare fraud, for the next 3 years. This is a very, very real thing. It's being staffed up as we speak. And I think at the very, very least, we can expect to see some pretty significant investigations. We'll see if there are successful prosecutions, but there will be investigations flowing out of this.
So let's talk about how those investigations will proceed. Basically, they will proceed via all the forms that federal criminal white-collar investigations typically proceed. That said, I think in an area like this, data is going to be the real driving force. And there are a lot of reasons for that, not least that the US government has extremely sophisticated tools for searching customs-related data. So one example being that the Customs and Border Patrol, which really has primary, and for a long time has had primary jurisdiction over these offenses, can search for things like how many imports are major US companies, let's say some kind of consumer electronic company that imports parts from China, or a retailer who imports goods from India, how often they're receiving imports, the average weight, the number of containers, the number of units, and they have the ability to look at that data over a period of time. So if there's some major retailer that is importing lots and lots of consumer goods from Indian factories, and then all of a sudden that goes to zero and they start importing them from another country, that's going to raise red flags, set off alarm bells, and they're going to start investigating. And they'll go to ports, they'll go to the port of Los Angeles, they'll go wherever the goods are coming in, and they'll just start popping open containers. Because another key fact to understand here is that by and large, when persons or containers are entering the United States, the Fourth Amendment, which prevents against unreasonable searches and seizures, does not apply to the same extent as it does once you're inside the United States. The US law permits what are called border searches, where, and this is important really for any executive, but when you're entering the United States or leaving the United States, law enforcement can search your bags, they can search your phone, they can search lots of different things that they ordinarily would require a warrant from a judge to search. So particularly in the area of tariff evasion and import and export issues, that power of the US government is extremely powerful, and is one that they rely on quite heavily. There are also, as Rob mentioned, and as Vanita mentioned in talking about the task force, there is a significant cross-agency element here, which is you have lots of people, Homeland Security, you have Customs and Border Patrol, you have FBI, you have traditional white-collar prosecutors in the fraud section, which is really one of the elite white-collar components of the Department of Justice, all working together to share information and investigate and prosecute these cases. There's also, and this is made quite prominent in the announcement for the Terror Fraud Task Force, there is quite a lot of encouragement for whistleblowers, including competitors, to bring information to law enforcement to investigate and prosecute these matters. So not only under the False Claims Act, which traditionally is available to corporate insiders, the DOJ Criminal Division Whistleblower Program permits competitors who have information about other companies who are engaged in criminal conduct to bring that information to the government and potentially receive a monetary reward for doing so. If there's a successful prosecution and there are fines or other penalties levied against those companies, then the whistleblowers can get effectively a bounty. In terms of techniques, as I said, there are border searches. There is effectively no barrier to interagency communication, and data that Customs and Border Patrol has will be available to the DOJ and to the fraud section prosecutors. Grand jury subpoenas are a very, as I'm sure many of you know, are a frequent tool that are used in white-collar prosecutions to go directly not only to the targets, well, to companies that are under investigation, that are subjects, may have committed wrongdoing, as well as witnesses like banks and others, to obtain information, and then potentially search warrants to the extent that there are facilities or companies that are based in the United States that have plants that do have a reasonable expectation of privacy and do have the full panoply of Fourth Amendment rights. The U.S. government would need a search warrant to go into those locations and seize evidence. So traditionally there have been three primary focuses, and Vanita touched on these in her introduction. There have been three primary focuses for investigating tariff evasion. Three forms of misstatements. The first is saying that goods came from one country when they really came from another. Obviously, the paradigm for that is you're in a country with very high tariffs, and you say that the goods are coming from a country with very low tariffs. This is often the most the grayest area, because what many companies will say is, well, part of it came from India, but then we shipped it to our facility in Singapore, and then we changed it, and our supply chain works such that raw goods come from one country, then they go to another, and they're improved upon, and then we export them, and they come to the United States. And the kind of key legal concept here is substantial transformation. If a good undergoes substantial transformation in an intermediate country, then it will be deemed to be an export of that country. As you can imagine, with the term as sort of broad and undefined as substantial transformation, that is a significant area for litigation. Then there are misclassification and undervaluation. Misclassification is essentially saying this is a cog when actually it's a widget. This is one thing when it's really something else. And then undervaluation is simply saying it's worth less than it is. So on this slide, this is the customs form, the actual form that an importer would fill out and submit to Customs and Border Patrol. And so you can see here, country of origin is box 10, and then there's a list of every country from which it could originate. And then 31 through 38 contain effectively the classification and the valuation information. So this is the actual form from which all of these data are obtained, and would really be the base. This would be sort of, exhibit 1 in any prosecution, where the government would say, here's the form. They said it was from Laos, and really it was from India. Rob, do you want to talk about prosecution techniques?
Yeah, so building off of what Dan just said, so we've talked about what the law is, what the likely universe of false statements are that the department will investigate and prosecute. Then the question becomes, well, how will they do it? And there's a pretty established formula that the Department of Justice uses in white-collar cases to bring cases to their conclusion. So it begins step 1 with either a witness, a whistleblower, either from inside the company or perhaps a competitor who provides information. That's kind of option number 1A. 1B is exactly what Dan said, is there are data analytics that are used to generate leads. In this case, there is a border search, meaning federal agents actually pop open crates and they look inside and they see what's what. So the cases will generally, in this space, originate through one of those two mechanisms. That's a human being or through data, and then there's evidence that's obtained. So once that happens, kind of step two is to secure the cooperation of an employee or agent of the company. And that's typically done through plea agreements. And so the Department of Justice will appropriately threaten an individual with serious charges and prosecution in exchange for their cooperation. That typically will result in either one of two outcomes. Either the individual will say, go to hell, I want to go to trial, or they'll plead and cooperate. And so that if the second happens, it will result in the execution of a plea agreement. And that plea agreement will have a provision in it that requires them to cooperate with the US government. Well, so what does that mean for companies? Well, here's the bad news. If an employee or agent of the company pleads guilty and cooperates, their conduct in almost every circumstance, there are a couple of rare exceptions, but very limited, their conduct is necessarily imputed to the company. It's called vicarious liability. So if that happens, the company is kind of over a barrel because they are basically, it's very, very tough to defend the case when one of your employees has said, I did it. And so that typically is how a case will evolve from origination to conclusion. There are things companies can do if an employee is pled guilty to mitigate the extent of the criminal harm through cooperation, through prompt remediation, through the uplift of their compliance program. But in substance, it's a fait accompli. There will be some type of criminal resolution if their employee has pled guilty and is cooperating. The question is just what form of resolution does it take? Go to the next slide here. And so in that light, as I said before, there are things a company can do to mitigate the extent of the criminal consequences associated with their employees' conduct. And so this slide, there's a lot on here, but I'll just boil it down. Before any misconduct is detected by the U.S. Department of Justice, a company does have at its fingertips an option. And there's a pretty clear roadmap to get leniency. And so that is if they self-report misconduct to the U.S. Department of Justice, this is before any criminal investigation. If they fully cooperate with the investigation and fully remediate, the company would be eligible for a declination. So this paradigm does not exist if the government finds out about the conduct first. A declination, to be clear, means no criminal charges. They drop the case. The company would have to disgorge profits, but there would be no formal criminal charge, which is of significant value. In the event the government learns about the case first, which frankly is oftentimes the case, there is still significant leniency available for a company. And here's how it would work. Although the company doesn't self-report, if they fully cooperate and they fully remediate, they potentially can receive up to a 50% reduction in the criminal fine. So not nothing, a 50% reduction is pretty good. So point number one, if you decide to do this, and we'll talk about when you might decide to do this, but if you decide to do this, the best thing on the table would be a full declination and some disgorgement of profits. If you decide not to do this and there's still an investigation, full cooperation and full remediation can lead to a 50% reduction. It's the bottom line in the fine. And then finally, this is our last slide, but it's a critical one. And just this summer, the U.S. Department of Justice amended their bounty program, which Dan talked about before. The bounty program allows individuals to get a bounty, money, for reporting criminal conduct to the U.S. Department of Justice. The bounty program, at the time it was rolled out year after last, was very specific as to the types of offenses that would qualify. Tariff fraud was not one of them. Well, that has changed. As of summer of this year, the whistleblower program of the U.S. Department of Justice has been expanded to include whistleblowing in connection with tariff fraud, meaning that employees of companies that are engaged in tariff fraud or potential tariff fraud could receive a bounty for reporting that conduct to the U.S. Department of Justice. And here's how the bounty would work. Up to 30% the whistleblower would get for the first $100 million forfeited, then up to 5% for any sums forfeited between $100 million and $500 million. And so, by my math, that means a whistleblower could receive up to, if the case is over $500 million, $35 million in a bounty. So not an insignificant sum. And so the idea is this is the carrot approach the department has offered to folks to provide information about tariff fraud. So again, I think the key points here are there are a number of different ways the Department of Justice can learn about tariff fraud: data, human beings, and on the human being front, there are significant monetary incentives for humans to report misconduct, as evidenced by this program. Dan?
Okay, so that's the end of our presentation. I think we'll have an opportunity for questions and answers towards the end, but I'll turn it back over to Vanita to continue.
Thank you. Thank you, Dan and Robert. This was very insightful. And just a few questions, follow-up questions from the presentation. So Dan, you mentioned about some of the red flags that could be flagged by the U.S. enforcement agency. For example, if the number of exports fall to 0. Are there any other red flags that you can think of that which can help the Indian companies to avoid?
Yeah, so it's a great question, and it's an evolving landscape because the creation of this task force is interesting and significant for many reasons, but it also reflects that this is not something that the fraud section has been doing, right? So the fraud section will be taking their lead in the first instance from the folks who have been doing this for years, which is Customs and Border Patrol, who traditionally have focused on those 3 key areas. So I think to start, those will continue to be the focus. I think one question that is still open is to what extent companies will avail themselves of the bounty program, and even just insiders who say, look, this is really how the scheme works. It's not as simple as what you, Customs and Border Patrol, have been investigating for decades. It's actually more nuanced. It's more sophisticated. There, I think we'll start to see some new paradigms for investigation and prosecution. I think in the short term, however, I would focus on those 3 key areas: country of origin, and in particular, there will be prosecutions and investigations related to the substantial transformation concept that I talked about before, which is, okay, fine, you drop shipped it to another country and you slapped a new label on it. That's not good enough. That's tariff evasion. That's not tariff avoidance. So I think the really important thing that Indian companies can do now is to make sure that they have a very strong record for any arguments that they wish to advance based on substantial transformation, is to really document as robustly as possible the ways in which the goods were changed in the intermediate country, and to show that there really was substantial transformation going on.
Thank you. Robert, you spoke about the whistleblower awards. Now, what is and that they have to produce the original information in writing. So is there any vetting done at the beginning or any information? Because anybody can produce even a false information, or what is the debt and what is the degree of filtration
Diligence
that they do?
Yeah. So I can only speak to my time at the U.S. Department of Justice. I've now been gone for 5 years, but I am confident the same exercise holds true, which is any individual who comes and talks to the FBI or a federal agent or the U.S. Department of Justice has an incentive to not tell the truth, every single person. And so corroboration becomes a very, very key part of this intake process. So corroboration, I'm sure we all know what it means, but it's just, is there backup support, documentary support typically, for what they're saying? Or are there other witnesses who will say the same thing? And so to initiate and open a case based on a whistleblower report, in my day, and I'm sure it's true now, there would need to be significant corroboration, because what's not going to happen is the department's going to invest 2 years in an investigation that turns out to be bogus for some person who's lying to them. Nobody wants that. It makes the prosecutors look stupid. It makes the FBI look stupid. And of course, the individual would be subject to prosecution for false statements to the government.
Thank you.
Yep.
Amit, for now, I know that you are from the pharmaceutical industry, and for now there are no tariffs. But what can a sector in which, and I think they have announced that the tariffs may be imposed in the future. What, according to you, are the steps that any sector can take from now to mitigate the risk that may arise in the future?
Thanks, Vanita. First and foremost, let me give a disclaimer that views that I express are my own and not of the organization that I represent. And though pharmaceutical have been kept out of the tariff as of now, but I think the days are not far off when pharmaceuticals will also be considered as part of the tariff. Now, I think Robert and Daniel gave a very beautiful presentation explaining the laws which are prevailing as well as the lookout for in terms of when the goods are imported into the United States. And one of the key things here that we're noticing, and particularly I can say from my experience, is the fluid state of the tariff, which is evolving every day. I mean, there's no certainty, and business doesn't like uncertainty, right? So, whenever a contract is executed with third parties, it's always on certain presumptions, certain stability of the land between the two countries, and most certainly we expect that certainty from the government. I think this has warranted a lot of changes to be brought about, and I think more or less we're seeing those changes happen. And we'll have to now consider whether the impact of tariff, how are we going to take that? Is there going to be a pass-through clause which needs to be inbuilt into the contract, whereby if there is any change in the tariff from the existing arrangements, we may have an opportunity to kind of relook at that. Force measure clause is another one which normally doesn't cover act of governments, but I think its scope needs to be now expanded to kind of include government decisions on tariff, which could significantly impact the transactions that a Indian company is having with anyone in the United States. There could be also provisions relating to reopening clauses to look at the changes in the terms and conditions, which normally for a longer period of durations people tend to keep, but I think periodically we'll have to look at and revisit that once the tariffs kick in to see if it's really making sense. Some companies have also seen resorting to insurance. Is this category coming into action because of the political uncertainties? So maybe a good idea to kind of look at some of the hedging through insurance products to see if you can, just in case if you anticipate tariffs getting beyond what you expected, to take care of that. And some of the warranties on the regulatory compliances, because every company is dependent on third parties who, as Robert and Dan said, go and make certain declarations on behalf of the company. So there has to be some warranties inbuilt to say that they are not committing anything beyond what the company statements are, and that is not building into the responsibility and obligation for the companies who are exporting it to United States. So I think there is a need for relook at the contracts, and I'm sure most of the companies are doing that. Uh, Pharmaceutical, particularly, is an essential commodity, so it will have an impact whether directly or indirectly. Unless and until capacity to address the needs of the patient in the United States is built, we don't foresee any impact, but we never know. As Daniel mentioned, that one cannot predict what the new tariffs would look like. So these are some of the things that on a contractual basis one needs to be prepared for.
Yes. Sorry for the glitch. Thank you, Amit. That was very insightful. Ayush, if I may call upon you, now, what, according to you, from an Indian perspective, what are the most common documentation pitfalls faced by Indian exporters when exporting to the US, and what can companies do to minimize their exposures to customs scrutiny and enforcement actions?
I'm glad that you asked that, Vanita, because as Daniel and Robert have very beautifully summarized the law positions, one needs to understand that these investigations or the proceedings pursuant to the investigations, are going to be a very fact-heavy exercise. And what this certainly is going to trigger is a enhanced or a very, very nuanced review of your entire supply chain. So, what we typically see is that people in the urge of saving a few bucks on tariffs, they tend to let go of minute compliance related requirements. And when I mention compliance related requirements, I also refer to the documentation which is often left to the customs agents to handle. But as you covered initially, while introducing the subject, and Daniel and Robert have already emphasized sufficiently on this, three things which are going to be critical is the fact that classification, country of origin, and valuation. This is going to be the focus of the customs and border protection and the other agencies which are going to be involved in at the US side. So their focus is largely going to be on tracing the documents back to ascertain that whatever claims are being made, they are true to the letter T. And we've seen as part of the Indian customs, I've been personally involved in some of the prosecutions. People tend to just take their suppliers on face value, and country of origin is often ignored. So, we even had a change in our customs law where the Karuta rules, the customs administration of rules of origin rules were brought in, which enhance the requirements at the importer's end to ensure that the country of origin related details, certain facts and the related documentation is collected at the time you are importing those goods into India. And the expression used there is the normal, reasonable diligence. Whereas now I think we've got to the stage that there is going to be enhanced scrutiny of your supply chain. Daniel and Robert have sufficiently emphasized on the point that the US government has very sophisticated tools, and I think there is real-time data sharing which is happening between the countries. So anyways, these countries, or most of these countries, are part of the World Customs Organization. So there's a lot of data consistency and uniformity which is expected at the supplier as well as the receiving end. So what I'm trying to say here is that now the onus is on the parties involved to ensure that in their supply chain, they are also going a step beyond to ensure that they are triggering the scrutiny of documents at their end so that they cross that threshold of reasonable diligence. And in that context, the entire supply chain needs to be mapped, because what we in India are getting a lot of queries about, whether I can shift my country of origin, whether I can apply the first sale principle, whether we can bifurcate my supplies in two parts where, I bill for supplies separately and then I also part bill it for some development services and so on and so forth. So these are the things which people, if they are going down that route, they need to ensure that they have sufficient and trustworthy documentation in place so that just in case they are questioned, you have all the document in place to prove your bona fides. So, that's what it's difficult to pinpoint the entire document trail, but the core point being that the entire supply chain documentation must be looked through a microscopic lens.
Thank you. Thank you so much, Ayush. Dan, coming back to you, you mentioned that the challenge is pending in the federal court. I mean, in your experience, we don't know what outcome might be, but in your experience, what are the grounds that have been taken, and do you think that there could be an upsetting of the tariffs? And if yes, what would be the situation of refund? We have a question also from one of the audience that apparently it's only 50% will be refunded. So what are your views on that?
Yes, it's an excellent question. If I could just add one thing to what Ayush just said, because I thought it was so insightful. I think a key element here, particularly for criminal investigations, is going to be showing companies good faith in trying to get this right. Customs, like taxes or anything else, is extremely complex. People are inevitably going to make mistakes, but if there's a way to really convey to prosecutors that the company was trying to get it right, that's going to go a very long way in avoiding the worst possible consequences. So I really thought Ayush's points were spot on. To your question, trying to guess what this Supreme Court will do in a case that is so politically charged like this one is really a fool's errand, I think. There are real legal problems with using IEEPA as a basis to pass tariffs. The US Constitution is pretty clear that it's for Congress to regulate foreign commerce. And although over the years, Congress has passed laws that have delegated a lot of power with respect to tariffs to the executive branch, to the president, there are limits. And there have been a number of significant constitutional Supreme Court cases on what's called the non-delegation doctrine that basically says there are certain things that Congress cannot give to the executive to control that have arisen in exactly the tariff space. So that also doesn't answer the question, right? Because ultimately, I think this is a political issue, and the Supreme Court is in a really difficult position with this case and many others that are so politically fraught. If I had to guess, I think the Supreme Court will find a way to permit the president to engage in these kinds of levying of tariffs while doing the least amount of violence to its own longstanding precedent. This precedent is not something that this Supreme Court is particularly hostile towards, unlike lots of other longstanding precedents. So I think there will be, for everybody on this call, the practical effects will be that the president will be able to control tariffs in some manner. And these issues are going to continue to be live issues. For the constitutional law nerds on the call, it may be a very nuanced or disappointing or disingenuous opinion. As far as the amount of money returned, I think it will depend country by country. And to the extent that there are existing tariffs that were not imposed via IEEPA, but were imposed via the traditional method that goes through Congress, if country A initially had a 10% tariff, and then the president said, now it's going to be a 20% tariff, then you would only get back half, right? If the tariffs are vacated, then the pre-existing tariff level would be the applicable level. For countries that went from 0 to 75%, then there really would be no legal basis to withhold any amount of the 75%.
Thank you. Thank you so much, Dan. Robert, a quick question from you, from our audience, that what is the level of protection given to whistleblowers, and also how, would the importers also be prosecuted, or it's only the exporters that will face prosecution?
Sure, let me take that in reverse order. So in the first instance, the importer is the one who's going to be responsible for the false statements on the form. So I would say in most cases, it's only going to be the importer, but you could imagine a scenario where the exporter is working in conjunction with the importer. And in that case, assuming there is a level of coordination and knowledge between the two, the exporter can also be charged in a conspiracy charge. That's an unlawful agreement, or as aiding and abetting, is substantially assisting the underlying violation by the importer. So to answer your question just directly, most times it's going to be the importer unless the exporter is involved in the misconduct. And if they are involved, there are ways to charge them. With respect to protections for whistleblowers, it's a great question. The answer is there are no statutory or regulatory protections on the criminal side. As a practical matter, there are really two to three types of whistleblowers. The first is an individual who has no personal knowledge of the conduct at issue, but suspects there to be some, and so runs in a complaint. That person doesn't need protection because they have no exposure. The second type of individual is an individual who has firsthand knowledge of the misconduct, but wasn't involved at all. That person typically would not need protection either because they weren't involved. They knew, they saw what happened, but they weren't involved. The third and more difficult kind, and actually the more useful kind for the department, is the individual who has firsthand knowledge but was involved in the criminal conduct. And so the question then becomes, well, for those people who want to be whistleblowers, what kind of protections do they have? So a couple key points here. Immunity is on the table. It's called a non-prosecution agreement. So it's immunity for people who come in and bring information to the government, who are involved in the misconduct, who are truthful and corroborated. They are eligible for a non-prosecution agreement. But to go down that road, the whistleblower needs to go in eyes wide open that if they make any false statements, or they're believed to have been making false statements, or they're shading the truth, they're concealing parts of the story, they could just get prosecuted. And not only would that bounce them out of the whistleblower program, that would expose them to jail time. So if an individual who is involved in the misconduct wants to be a whistleblower, it is possible to get immunity and it's possible to get a bounty. But you have to be very, very careful and totally transparent with the department about what you know and how you know it.
Thank you. Amit, a very quick question, since we are running out of time, that as a in-house general counsel, what do you think that the companies should do to, internal controls in order to, in order to do their data management, and also to, prevent such, and how to, train the employees?
A very good question, Vanita, because as you know, Robert and Daniel have given the complete scenario of how the United States government looks at the tariff-related aspects, including the tools that they have to kind of decipher the truth behind where the products are landing from. I think training is one aspect which is very important, because you really have to invest in training the people who are involved in these activities, including your third-party vendors who would be undertaking those kind of activities. And when I mean by training, it's just not the normal routine training that the organization does by way of a video or a routine kind of a document is sharing. It has to be a training which is based on the real case scenarios, and one has to kind of take them through. Uh, as you know, as we got to know that there are basically three kind of liabilities, or the situations where you can get caught, and why these three situations are important. One needs to understand that, and one needs to also understand that no matter how much of a smartness one plays, ultimately the system will catch it, and it's not worth it. So I think that aspect has to be deeply understood by each and every person who's involved in this. Second is how much of a delegation you're doing, how much of an authority you're giving to each person who is involved in the process. Are we really understanding the harmonization schedule, which is the key in terms of where we are categorizing the goods or products to be applicable to tariff? So that needs to be done by people who understand the code properly. It needs to be understood by people, and they need to kind of see that a maker checker normally helps. And particularly with this volatile situation, I think there's a need for more attention towards that. Third is, not only tariffs, but I think United States is also, in a large way, because of the geopolitical situation, is sanctioning many countries and many areas we can't do business with. So who are your suppliers? Who are your partners? Are they really in that list that can bring trouble to you? So I think a due diligence of your suppliers and your partners is also important. You can't hedge all your supplies in through one shipping company, which could potentially land into some kind of a problem later on, right? So you have to kind of diversify that area also. I think everyone is learning the new trades of the game, because it's impacting their balance sheets, and it's impacting their margins in terms of what they expect doing business with the United States. So uh, I think it is an evolving landscape, and there's no one fit solution for all. But I think if you stick to the basics, probably you are better positioned to kind of deal with the situation.
Thank you so much. Ayush, a very quick one for you, because I think now we have reached the end of the webinar. But any last thoughts, and anything on how, because we have discussed any differences between how prosecutions happen in US and India, and can that give any insight to the companies on how to function in this scenario?
So, that's a very pointed question. And in fact, I would say that there's the two investigation and the related proceedings are largely similar. But to the point what Robert and Daniel were also trying to emphasize earlier, I think I tend to agree with them that these are going to be fairly fast-tracked investigations and really intrusive. So what one needs to keep in mind is the fact that since these are going to track the entire supply chain, it's important that you have both a local as well as an international counsel, because the fact finding is going to be critical. The fact presentation is going to be even more important. And the couple of key points that people need to keep in mind is, protecting the privilege and structuring the confidentiality. That has to be kept in mind, because unless you are the general rule is that unless you are speaking to an advocate or a lawyer who's entitled to practice in that jurisdiction, the conversations are not privileged and not confidential. So it's important that you structure that communication, because there certainly is going to be information which is which can incriminate. The other point is, it's important to also understand, and this was covered as part of the presentation by Robert, that there are certain options available. Disclosure option is there, plea bargain is there, and to avoid criminal prosecution, it's important to identify which option suits best to you. But at the same time, you need to ensure that your compliances in that jurisdiction do not trigger any parallel compliance, because in all likelihood there's going to be a corresponding offense in another jurisdiction. In case it's not India, it would be some other jurisdiction from where you may have triggered the misdeclaration in the supply chain, or triggered a false claim in the supply chain. So all these things need to be kept in mind. So it's important that you have the two set of lawyers aligned right from day one, because that will ensure that the information flow is integrated and you have a real-time exchange of information between the critical stakeholders. So, those are my parting thoughts. Happy to take any questions.
Thank you so much. Thank our panelists. I think, Niloji, we have run out of time, and but we thank the panelists for this most comprehensive and helpful, seminar, the webinar in such a short time. Thank you very much.
Thank you so much to all the panelists. Thank you so much, Vanita.
Thank you.
Thank you.
Thanks
Thank
very
you.
much.
Thank you.
Thank you, everyone.
Bye.